Hello friends, in the series on the income tax cases, today we will discuss the issue of levy of penalty under section 271B, where the assessee fails to get its books of accounts audited under section 44AB. The question which was discussed in this case was that in case assessee does not maintain the books of accounts, so in that case, whether the penalty for non-maintaining of the books of accounts should be levied or the penalty for getting books of accounts not audited should be levied, or both the penalties should be levied. This issue has been taken by the Honorable ITAT of the Rajkot Virtual Court, and this case has been reported in 110 ITR Tribunal Short Notes 14. The date of the judgment is 17th January 2024. The present case relates to the assessment year 11-12 and 12-13. In the present case, the assessee has not filed its return of income under section 139 subsection 1. The department has the information that the assessee has entered into some transactions, and on the basis of the concept of escapement of income, the notice under section 148 was issued to the assessee, and the assessee filed the return of income in response to the notice under section 148. In the present case, there was no ambiguity about the fact that the books of accounts were not maintained by the assessee up to the date of filing the return of income under section 139 subsection 1. There was no doubt about that. So, when the assessee has not maintained the books of accounts, the question of getting them audited does not arise. One more thing is that if the assessee does not maintain the books of accounts, then there is a separate penalty for that under section 271A. The assessing officer, obviously, when he found that the assessee has not get the books of accounts audited, so he levied the penalty under section 271B, which was confirmed by the CIT appeal also. When this matter came before the tribunal, it was the viewpoint of the assessee that there is no doubt that the assessee has not maintained the books of accounts, and there is separate penalty for that, and the event of getting the books of accounts prepared comes first, and then the stage of getting them audited comes. So, if there is a separate code for levying the penalty for getting the books of accounts maintained, and if that penalty is to be leviable, then for the same offence, the penalty under separate section should not be levied. Meaning thereby that the assessee has not maintained books of accounts, there is penalty for not maintaining the books of accounts. So for the same offence, if the penalty for getting books of accounts not prepared is to be levied, and then again the penalty for getting books of accounts not audited, then it will be a double penalty for the assessee, and that is not the intention of the law. So in the present case, tribunal said that in the present case the assessee failed to write up books of accounts before due date of filing return of income. There is offence of non-maintaining accounts, and that is a separate offence, and there is a separate penalty for that. So in the present case, when the assessee has failed to maintain the books of accounts, then in that case there is penalty under section 271A, and if the department goes for the penalty under section 271B, that is not justified and that is not as per the law. The same issue has come before various tribunals, and in that matters also, in the various cases, the tribunals have taken the view that in the same facts and circumstances, the penalty for not maintaining the books of accounts is separate, and the penalty for getting them books of accounts audited is separate. And in case when the books of accounts are not maintained, then in that case the penalty under section 271B should not be levied. the penalty under section 271A should be levied. Both the penalties cannot be levied. At the end of this video, once again I am repeating the name of the case. The name of the case is PRADIPBHAI, Dayabhai, Aghara versus Income Tax Officer, and this case has been reported in 110 ITR Tribunal short note 14. The matter has been decided by Rajkot ITAT Virtual Court and the date of the judgment is 17th January 2024. Thank you friends.